Service. And with the patience of my colleagues, I'd like to go ahead and introduce Senator Frank Lautenberg. Before I do, I will just say that it's a remarkable moment for me personally to be chairing a body with a witness this morning who spoke at my high school graduation in his first year as a United States Senator, first full year, and for whom I interned for 10-plus weeks in 1985, and truly that experience sparked my interest in public service and also particularly in environmental and transportation policy. So, Senator, bear with me if I get or look nostalgic for a moment, but it's truly an honor to have you here. You are always welcome in our offices here at the Surface Transportation Board. You have an excellent staff we enjoy working with, and without further ado, I'll give you a chance to say your piece, and thank you for being here today.
Thanks very much, Mr. Chairman. I don't know whether each of us has to recuse ourselves because of our previous contact, and the chairman knows my children and graduated with one of the four of them. So I guess we'll have to be objective, though, here, and I would hope that you'll be objective with me, Mr. Chairman. Mr. Chairman and Commissioners, thank you very much for having the opportunity to express a point of view that we in New Jersey are concerned about. Now, I currently serve as the chairman of the Subcommittee on Surface Transportation and Merchant Marine of the Senate Commerce Committee. Now, as all of you know, my subcommittee has the sole jurisdiction over the railroads and the Surface Transportation Board. And while I'm interested in the board's action as that committee's chairman, I'm particularly here as an advocate for New Jersey's 9 million residents. They've got strong feelings about the issue before the board today. When it comes to ensuring the safe handling and processing of solid waste near railroads, the ramifications of the case go beyond the Wilmington and Woburn Terminal Railway Company in Massachusetts that you're reviewing today. New Jersey wants to take care of the responsibilities that we have to our citizens, to make sure that their health and safety is protected. And so we want to do that through effective regulation of solid waste processing. And that's why our state actively inspects solid waste processing facilities and enforces our laws to make sure that they meet safety, health, and environmental standards. The problem for New Jersey and for other states is when a solid waste processor sets up shop next to a railroad. Now, in New Jersey, solid waste processors have sought out railroads not just for ease of transportation, but because of an ambiguity in the federal law. Some processors use this ambiguity as a shield from state health, safety, and environmental regulators. And as you will hear today, there's a concern about this across this country. Now, I've introduced this legislation to make it clear that solid waste processing facilities, even if they're next to a railroad line, are subject to state regulation. That's our view. My bill also preserves a uniform federal regulation of rail transportation that's so important to interstate commerce. Now, senators from various states support my bill, and there's a companion legislation in the House of Representatives. But there's a faster solution to the problem. And that solution, Mr. Chairman, is by actions of this board. The board can clarify the state's authority to regulate solid waste. Thank you. Solid Waste Authority to regulate solid waste processing facilities at rail sites. And then there wouldn't be any need for legislation. The bottom line is that states should be allowed to regulate solid waste processing. They know best what protections are needed to safeguard the workers, the residents, and the environment. Congress never intended to set up a regulatory void for some solid waste processors. So I urge you to move quickly, take action here. If not, I have no recourse but to move legislation on this issue and exercise my subcommittee's oversight responsibility for the Surface Transportation Board. It really is hard to understand why it is that facility that has potentially such an effect on the environment, the health and the well-being of people in the area, and is offline, to use the expression, can't permit this, can't allow the states to do their own regulation on the issue. Now, I understand there is a complication here, but that, once again, Mr. Chairman, and thank you very much, and I'm pleased that you were a part of my office at one time and that you've advanced as far as you have with knowledge and experience and have made a career out of understanding transportation issues, and you've done it well. But I do ask for your diligence in considering this issue. I ask you and the other commissioners, please consider this issue, and we look forward to its prompt resolution, and I hope that's coming. Thank you very much for the opportunity to appear before you.
Thank you, Senator Lautenberg. Thank you, Senator Lautenberg, for your very articulate testimony, and you can be assured we will be handling this in an expeditious manner. It's a very high priority for this body to see this matter through. I can assure you also that since it's been 21 years since I worked for you, and I don't think I was actually compensated, so I think the recusal situation can be easily avoided. As any kind of statute of limitations, I think, is long expired there. But I know all of us will be looking at this matter with a completely open mind and in a fair, impartial manner. I know I will. And thank you for your time this morning. And I'll yield to my colleagues if there's anything they'd like to say.
No, I just want to join the chairman in thanking you for coming and sharing your views with us. We're very, very sensitive to this issue. As you may know, I spent some years myself in the solid waste area with the state of New York and gained a lot of familiarity with the problems of municipal solid waste. So we're very, very sensitive to these problems. Thank you for coming, sir.
Thank you.
Vice Chairman Buttrey.
I have no questions, Senator, but I just want to tell you how happy we were to have you here today with us and to share your views with us about the concerns of the citizens in New Jersey. And I would add one little personal note that I spent time on the Commerce Committee myself as a staff member for about 3 years, and it was a wonderful experience and one that I will never forget. Thank you very much.
Thank you all.
Thank you, Senator. And you're, of course, welcome to stay as long as you'd like. Your staff, I know that you have a tight schedule, so we understand if you need to slip away. And the large photo you brought is certainly well noted, too.
We have these sites, and these are displays of what happens in the state of New Jersey with this trash gathering mechanism here. And this is quite close to residential and economic and business facilities. And if I may, please, Steve, each one of these, and this is not a form of pop art. As a matter of fact, it's if you look at it, it's, I would say, if I was a reviewer of the picture, I'd say it's disgusting, and that we ought to be able to, please, Steve, to take care of this. We don't want to stop the process. We want to control it so that it doesn't spread havoc and threat to the nearby residents and people who visit in the area. Each one of these pictures goes quite directly to the problems that we see evolving. We had a fire in one of these stations, and we asked that the facilities be built safely, that we control any liquid runoff, etc. We're not saying, look, don't stop doing this, because it's a part of our economy. It's going to get to be an even bigger part. As we discussed, Mr. Chairman, forgive me this overrun, but as we discussed inside, that the capacity of rail services essential for our national well-being and functioning. And so there isn't any reason why it can't be done in a fashion that's consistent with the well-being of the people who are affected by these things, and to move them, I think. I come from the corporate world. I think that it'd be a lot easier to have an ability to control the environment in which these facilities operate and get on with it and expedite the processing by having a functioning infrastructure that also is appropriately nearby those who live in the area and who are there in the area for other reasons. So, thank you again. Thanks for the reminder about our art gallery here. Appreciate it.
Thank you very much.
Thank you, Senator. We will now proceed with opening statements from board members. I'll exercise the privilege and begin, and then yield to the Vice Chairman and then Commissioner Mulvey. New England Transrail, NET, has sought authority from the board to acquire and construct a combined 7,500 feet of track on a parcel of land in Massachusetts, about 12 miles from downtown Boston. NET plans to receive by truck at the site and provide rail transportation for a variety of commodities, including sand and gravel, plastic resins and liquids, and, at issue here today, municipal solid waste, and construction and demolition debris. NET asserts that it will operate as a common carrier and will engage in interstate commerce by connecting its rail line to existing railroads. The board is being called on to determine whether NET is a rail carrier, and if so, whether its activities at the facility are integral to transportation and thus preempted from most state and local regulations. In reaching a decision in this matter, I will be guided by two simple premises. First, that the STB must abide by the clearly worded language contained in federal statute. And second, that the STB must not allow Congress's broad grant of preemption from state and local regulations to compromise federal health and environmental standards. I believe that both of these premises can be honored when applied to the facts of this case. Today's argument marks an important juncture in a regulatory and environmental review process that will likely take many years before concluding. If the STB finds that it has jurisdiction, this agency will have a number of opportunities to protect public health and the environment and to accommodate the reasonable local, state, and federal concerns consistent with federal law. In the end, I can assure my colleagues on the board and all interested parties that I will not approve a railroad project that is allowed to evade federal health and safety standards, or a project that is allowed to operate free of inspection and free of meaningful recourse for local, state, or federal officials concerned about health and environmental compliance. I look forward to hearing today's participants address the full range of issues presented, including what did Congress mean in the Interstate Commerce Commission Termination Act, ICTA, when it stated that the STB will have exclusive jurisdiction over the construction, acquisition, operation, abandonment, and facilities of a rail carrier. What provisions in the statute would give the STB discretion to selectively apply the broad grant of preemption to some types of rail operations, but not others? Assuming that STB retains broad jurisdiction to regulate operations by rail carriers free of state or local regulation, what measures, procedures, or conditions may the STB impose to ensure that state and local governments have a meaningful way to ensure that appropriate health and environmental inspections are made and that prompt and forceful STB intervention or delegation of that intervention can be assured in cases where carriers deviate from federal health and environmental standards? Additionally, if a specific activity at a rail facility is clearly integral to transportation, but also happens to be a routine activity undertaken during processing or manufacturing, does the STB have the authority to ignore the transportation nexus and thereby avoid applying the broad statutory preemption provided for rail operations? If the STB has this authority, what would prevent the STB from removing the preemption status from a wide range of long-standing rail operations that might fall out of favor with local and state governments for a variety of reasons that may have nothing to do with health or the environment. And finally, should the STB consider the costs and benefits and public policy issues raised by preempting rail carriers' operations involving the transportation of municipal solid waste, or MSW? Should the STB promote rail transportation of a lawful commodity that contributes to highway congestion and in the course of doing so addressing public concern over truck traffic? As these questions indicate, I am concerned that we adhere to Congress's clearly stated statutory grant of preemption to railroads, while also protecting the broad public interest by ensuring that no rail operation under our purview is able to jeopardize public health or violate federal environmental safeguards simply because they fall under the STB's regulatory purview and are preempted from state or local regulation. Finally, I think it is important to note that regardless of the arguments today and the STB's decision in this matter, it is unclear that NET's proposed project will clear the US EPA Remedial Investigation Feasibility Study, or RIFS, process related to the Olin Superfund site on which NET proposes to operate. And it is also unclear whether, if we were to assert jurisdiction, the results of the STB's environmental review process required by the National Environmental Policy Act, or NEPA, would allow NET to operate at all, or perhaps operate only in a limited manner. The STB would, during the NEPA process, carefully listen to and try to accommodate all environmental concerns. US EPA has recently notified the STB that it has made no progress in 12 months towards beginning the RIFS. The STB would be unable to complete our environmental review until US EPA has completed that work. In sum, it appears that we are many years away from the completion of the environmental review process required before any possible rail operations may commence on the former Olin site. We will have many opportunities to weigh in on this project in the interim. Just a few procedural notes regarding the testimony itself. As usual, we will hear from all the speakers on a panel prior to questions from the commissioners. Speakers, please note that the timing lights are in front of me on the dais. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. Please do your best to keep to the time you have been allotted. I assure you that we have all read your statements and comments in their entirety, and there is no need to read the entire statements here. After hearing from the entire panel, we will rotate with questions from each board member until we have exhausted the questions. Additionally, just a housekeeping reminder for everyone to please turn off your cell phones. And now I'd like to turn to Vice Chairman Buttry for his opening remarks.
Thank you, Mr. Chairman. I think we've all heard the old saying about sunlight being the best antiseptic. So I think I'm hopeful that today's oral argument will shed some light on the very important question of just how far this board's regulatory powers do go and do not go. The Constitution of the United States in Article 1, Section 8 specifies that it's the federal government that has the power to regulate commerce among the several states. Accordingly, Congress has given the board exclusive jurisdiction over transportation by rail carriers. This preempts state and local authorities from regulating in that area. The 10th Amendment, however, makes clear that all powers not delegated to the United States by the Constitution are reserved to the states respectively, or to the people. This preserves the police powers of states and localities and their authority over matters relating to the health and welfare of their citizens, so long as they do not intrude on matters that fall under exclusive federal jurisdiction. So the question here is whether New England Transrail's proposed activities, all of them, some of them, or none of them, will be found to be transportation by rail carrier that is subject to the board's exclusive jurisdiction and shielded by federal preemption as part of interstate commerce, or whether all, some, or none of these proposed activities will fall under state and local regulation. This distinction will have significant repercussions, thus the high level of interest in this proceeding. The Interstate Commerce Clause is an essential part of our constitutional framework of government. Federal preemption protects the bona fide elements of our national rail network from a patchwork of local regulation that would hamper its efficient functioning. The question we must address is just how far that protection extends. The issues raised here will require our careful analysis of the facts of this case. I hope and trust that the parties have come prepared to discuss in detail the questions that were set out in the board's decision of March 29th, and any other questions that my fellow board members and I will have for them today. I look forward to the hearing of the statements. Thank you, Mr. Chairman.
Thank you, Vice Chairman Buttry. Now we'll turn to Commissioner Mulvey.
Thank you, Chairman Nottingham. Good morning and welcome to our panelists and other interested parties. I'd also like to acknowledge and to thank our staff who spent a great deal of time wrestling with the record here and who have assisted me in preparing for today's hearing. I'm glad we're convening this proceeding to get answers to questions we still have after numerous evidentiary filings about the proposal before us. I come to this argument with two views that I must reconcile. First, I have always been a strong supporter of preemption. Congress and the courts have long recognized the need to regulate railroad operations at the federal level to avoid a patchwork quilt of state and local regulations. The Interstate Commerce Act is one of the most pervasive and comprehensive regulatory schemes among all of our laws. The ability to preempt state and local laws is one of the prized benefits of receiving board authority to build and run a railroad. But because we are empowered to interpret and apply the Act, we are responsible for ensuring that preemption is warranted as a consequence of our decisions. Second, I recognize that preemption can jeopardize protection of the public interest, especially health and safety. I'm concerned about the regulatory gap that can result from preemption. Indeed, I've been concerned about it since I first dissented in one of the cases that came before the board shortly after I joined the board of the Surface Transportation Board. Who looks out for the public interest when federal preemption deprives state and local governments from doing so? I view this argument today and this case as pivotal. What this case comes down to is the need to distinguish between rail transportation and other activities that would occur even absent rail transportation. There are a number of proposals similar to that of the New England Transrail case in various stages of development around the country. So the answer to this question will impact our citizens and communities across the nation in a direct and visceral manner. It is imperative that we get the answer right and that we get it right quickly. I urge the parties today to focus on the distinction between rail transportation and other activities, as well as on the questions we posed in preparation for this argument. I am eager to take part in today's debate amongst the parties. Thank you, Chairman Nottingham. I look forward to hearing the witnesses.
Thank you, Commissioner Mulvey. Our first panel will be comprised of the Honorable Kirk Van Tyne, representing New England Transrail, LLC, Mr. G. Paul Motes, representing the New York, Susquehanna, and Western Railway Corporation, and Mr. Frank Damasi. Mr. Van Tyne has been allocated 45 minutes, Mr. Motes 20 minutes, and Mr. Damasi 5. And if I could just take a moment to give a special welcome to Mr. Van Tyne. I had the opportunity to observe his public service close up while I was at the Federal Highway Administration, and he was upstairs in the exalted territory of the 10th floor at DOT headquarters, serving as general counsel and also as deputy secretary. And Kirk, you're always welcome here, and thank you for being here. It's good to see you again.
Thanks very much, Mr. Chairman, and preliminarily I want to assure you that we won't object to your association with Senator Lautenberg, since our association was more recent. First, I want to thank Chairman Nottingham, Vice Chairman Buttry, and Commissioner Mulvey for scheduling this hearing. This is a real opportunity, I think, for us to communicate directly to the board and with the other parties. And there has been a lot of paper exchanged, but I think a lot of that paper has been sort of passing in the night, and it hasn't really been a dialogue. And we would like to promote a dialogue, and you have taken a great step forward in scheduling this hearing. Preliminarily, I want to say that I listened to what Senator Lautenberg said, and I couldn't think of anything that he said that we disagree with, that we share his concerns about public health and safety, and we want to assure everyone here and everyone who's not here that the facility that we propose and the operations that we propose will be mindful of the public health and safety. And I think the trick here, the problem before the board and before all the parties is how to protect the public health and safety while doing so in a way that is in accordance with the existing law, the large body of case law, and the fairly clear statute, and do so in a practical way that involves cooperation between federal authorities, state authorities, and the regulated parties. And just one more preliminary thought for you to consider as you hear the speakers today. Commissioner Mulvey mentioned the possibility of a regulatory gap, and I would suggest to you for your consideration that there really is not a regulatory gap, that this is not a new issue. This issue with regard to C&D waste and MSW has arisen relatively recently, but the issue of what activities are within the board's transportation jurisdiction and what activities may be preempted is an old issue, and it's been around for a long time, and the board has in many decisions, and the courts have in many decisions, taken steps to fill that regulatory gap with some content. And I would suggest to you that if you look to the past decisions, there are guidelines there that you can use to fashion a solution that considers the interests of all parties and all the interests in these kinds of cases as well. I'd like to, with the board's permission, divide my time, since we have both the opening and the closing statements, devote 10 minutes to the opening and 35 minutes to my closing. And if it's all right with the board, I'd like to proceed.
Please proceed.
Thank you. As I said, I think that one of the problems to date in this case is that the positions of the parties have seemed to be set in stone, and the paper pleadings pass almost unread. I think that a lot of the facts that we have tried to put forth in our pleadings seem to have been missed by the parties on the other side. And I want to, again, assure that we understand all of the concerns of all the parties to this proceeding. We understand the board's concerns, and we've never suggested that the board should ignore any of those concerns or minimize them. But we believe that there are ways to address all those concerns, and as I said, we've been trying for some time to engage in a dialogue with the parties to reach workable solutions. I'm going to spend some time in my closing statement to try and give you some suggestions about how the board might satisfy everyone's concerns in a decision in this case. I want to, before I go any further along those lines, I want to make sure the board is aware that more than a year ago, we proposed in writing to enter into an agreement with the Commonwealth of Massachusetts and the Department of Environmental Protection. And a copy of our proposal is in the record. And although we never received a written response, we were told that Massachusetts was not interested in talking, at least at that time. Just this morning, we filed a supplemental verified statement of Mr. Rob Jones, who is one of the principals of New England Transrail, in which he reiterated that we are still interested in discussing our proposal with Massachusetts. And in that statement, he also addressed several other issues that arose in the briefs that were filed on Monday. And I'll be referring to Mr. Jones' statement on a number of issues in the course of the day. Right now, I would like to pass up to the board members copies of both the proposal that we submitted to Massachusetts to make sure that you have it in front of you, and also in the package there is a copy of Mr. Jones' verified statement that, as I said, we filed just this morning. We have served the verified statement in accordance with the rules, and we have also made an effort during the hour before the hearing commenced to pass out the verified statement to all of the participants in the proceeding by hand in the hearing room here. And if there is anyone any participant or anyone else who would like a copy and has not received one, the copies will be available before they speak, so I have an opportunity to take a look at it. As I said, I think thus far our opportunities to engage in the dialogue have been pretty much a one-way street, and there seems to be an all-or-nothing attitude with the opponents of the project. And we were somewhat disappointed to see that attitude again in their written responses to the board's questions that were filed on Monday. I think the board directly addressed the issue by asking whether it is possible to fashion a workable system in which the states and the federal authorities and the regulated parties work together. And unfortunately, a number of the parties took the position that it was not possible. And as I said, I'll be coming back to that again shortly. I want to take just 1 minute now to discuss a few of the facts about our proposal that seem to have gotten lost in the mass of documents that have been filed. First, we're proposing to operate as a common carrier for compensation. We're proposing to connect to the National Rail Network. We're proposing to enter into agreements with other railroads. And we're proposing to build a state-of-the-art transloading facility. We've done a lot of thinking and a lot of engineering work, and we're going to build this facility with the current best practices, and we're going to manage it with the current best practices. We're well aware of the problems that have arisen in some other locations, and we've tried to learn from those experiences and figure out how to design and operate New England Transrail in a way that minimizes all of those problems. I also want to point out that in our filing on Monday, we discussed in some detail the backgrounds of the 4 principles of New England Transrail. Collectively, they have experience in rail issues, trucking issues, freight movement, and environmental issues. And these 4 people have had careers in the transportation sector, and they understand very well how the proposed facility would operate and how it fits into the nationwide rail transportation network. And I want to mention, too, that 2 of those principals, Mr. Rob Jones and Mr. Ron Klempner, are here with me today. And they'll be available to talk with anybody who wants to talk to them about their backgrounds or about any of the facts relating to the project. Now, one final word conceptually about the project. We hear a lot in the transportation sector about so-called last mile infrastructure, and we hear that there is a critical need in the United States for more last mile infrastructure, connecting up things that already exist. And I would just suggest to you that conceptually, this project is exactly that. This is almost literally the last mile from existing rail facilities to the surrounding area. And it would provide, it's clear that the area is underserved in the rail area, and this facility would provide a missing link. I know the issues presented in this case are important policy issues for the board, but as I said, they're not new ones. The balance between local health and safety concerns, local economic interests, and the nationwide rail network has been a constant issue, probably dating back to the day the first railroad started operations. As a consequence of that history, though, the good thing is that we have almost 100 years of case law on the legal issues in this case, and we have very explicit statutory guidance from Congress. And I think it's useful to point out that the opponents of the project are essentially asking the board to ignore or overrule all of that case law and ignore the express language of the statute. Obviously, we don't think that's the right approach, and from what I understood from the opening statements, I sense that the board is struggling with that issue as well. We think the purposes of the existing statute are very clear and that they're still valid. We suggest that instead of changing the law, the parties should be encouraged to resolve their differences in the same way that railroads and local authorities have tried to resolve the differences in the past by reaching agreements that satisfy valid health and safety concerns while not imposing an unreasonable burden on rail transportation. There have been a number of recurring misconceptions about this project, and I'd like to take just a minute to summarize our responses to some of the key factual questions that have been raised. And these points are all in the verified statement of Mr. Jones that I just passed up. First, neither New England Transrail nor any of its principals nor any of their affiliates is going to be acting as a shipper or receiver of the C&D waste and MSW that are transloaded at the facility. Second, the activities at the facility would not add value to the C&D waste or MSW. The purpose of those activities is to facilitate loading into rail cars, to prevent damage to rail cars, and to improve the safety of rail transportation by providing for more even weight distribution. Third, New England Transrail will not earn revenue as a result of the shredding of C&D waste or the baling of MSW. Those activities are intended to improve the efficiency of loading those wastes into rail cars. And finally, no wood or metal is going to be removed from the waste stream. Large pieces of wood or metal will be temporarily set aside and will be loaded separately after the smaller pieces of C&D waste. The purpose of setting those large pieces aside temporarily is to allow more complete loading of the rail cars and to prevent damage to the rail cars. Those activities all facilitate transportation. And again, all the foregoing facts are set out in the verified statement of Mr. Jones that we filed this morning. I think that concludes my opening statement, and I'd like to reserve the remainder of my time for my closing, but I'd be pleased to answer any questions you may have.
Thank you, Mr. Van Tine. We will hold back on questions till the full panel has given their statements. We will note that you've asked that 35 minutes of your time be kept for your closing, and you are very much on that schedule, and we will provide that to you. I will note for the record, for those who are listening over the internet through our webcast, that Mr. Van Tine has distributed two documents. One is a October 14, 2005 letter to Ms. Susan Rooch of the Office of General Counsel of Massachusetts Department of Environmental Protection. This letter is already in the record and is available to view via the internet. The second document is an April 19, 2007 letter to the STB's secretary. This was filed today and will be available on our website as well. And Mr. Van Tine's already been kind enough to say that they will be distributing copies to anyone interested today. With that behind us, we'll now turn to Mr. G. Paul Moats, representing the New York, Susquehanna, and Western Railway Corporation for no more than 20 minutes.
Thank you, Mr. Chairman. Vice Chairman Buttry, Commissioner Mulvey, it's a pleasure to be here in your new building. I, on this occasion, represent the New York, Susquehanna, and Western Railway, a regional railroad with lines in New York and New Jersey. I believe you're familiar with it. And before I go on, also greetings to the staff. Good morning. You all look more comfortable up there than you used to in the old facility, and I hope that's true. I'm on a panel with Mr. Van Tine, and I'm privileged to be here with him, but obviously I don't represent the New England Transrail, and candidly I know relatively little about the proposal of the New England Transrail beyond what I've read as you have in the docket. So the obvious question is, why am I here? Why is the New York, Susquehanna, and Western here? I think you have a pretty good idea, but let me be clear about it. I'm here because many of the issues raised in this proceeding are of vital importance to the Susquehanna and are squarely raised in litigation in which my client and the New Jersey Department of Environmental Protection and the New Jersey Meadowlands Commission have been involved for more than a year and a half, and which have now made their way to the United States Court of Appeals for the Third Circuit. The board should understand that we are before the Third Circuit on an expedited appeal from a decision issued on February 21, 2007 by Judge Hayden of the U.S. District Court for the District of New Jersey, a decision that is a 37-page, carefully written opinion that followed multiple hearings, development of an extensive record, a trial, and complete briefing. That is a very, very comprehensive record. It's an enormous record, having spent some time in the last day or two just trying to work with the appendix to go to the Court of Appeals. Take my word for it, it is a massive record that has been compiled in what we refer to sometimes as the Jackson litigation. That district court in Newark squarely held that New Jersey's efforts to invoke a claim of police powers to justify the imposition of an extensive regulatory regime on the Susquehanna's operation of several construction and demolition, or C&D, facilities in North Bergen, New Jersey, were preempted by ICTA. And that is a decision that the Third Circuit declined to stay, notwithstanding New Jersey's filing with that court of a motion for an emergency stay, in which it said the public will be badly harmed, there'll be irreparable harm if you don't stay this decision. The court didn't see it that way, it didn't stay. It did grant New Jersey's alternative request that that appeal be handled on an expedited basis, and it is. And indeed, New Jersey's opening brief is due next Tuesday, the 24th of April. Susquehanna's brief in reply or in opposition is due just 2 weeks later on May 8th, and New Jersey's reply 1 week after that. So that case will be fully briefed before the Third Circuit by May 15th. Will that court hold an oral argument? I would hope it would, but I don't know. As we sit here today, we have not been informed that it will, but the case will be briefed to the court by mid-May. Why did Susquehanna initiate that case? Frankly, it was forced to do so in August of 2005 after the NJDEP, the New Jersey Environmental Department, not only promulgated extensive and very burdensome regulations addressed, and this is important, by definition only, by the very terms of this act, these regulations apply to one thing and one thing only, railroad transloading facilities within the state of New Jersey. And then it issued an administrative order telling the Susquehanna that it was in violation of a number of aspects of these newly promulgated regulations, and it assessed a $2.5 million fine. As the board knows, however, the NYSNW, while a real railroad, is a relatively small railroad. It's 400 miles. Its lines and facilities are exclusively within the states of New Jersey and New York. And candidly, a fine of that magnitude not only threatened operation of the transloading facilities, it may well have threatened the railroad's very viability, especially with the quite real threat that the state would continue to assess more fines for other claimed violations of its regulations. So we initiated the Jackson case because, frankly, we were forced to do so by the state's actions, and the state knew that that would happen. Now, we, the Susquehanna, take no position on the merits of NET's exemption petition, nor do we believe it would be appropriate to comment on whether NET's proposal demonstrates that it would, in fact, be a bona fide rail carrier. That is a question that you and your staff are very well capable of answering. There are very clear standards for determining whether a rail carrier will come into existence, and you will judge their petition accordingly. But we do ask you to move very carefully in this case to avoid making any broad pronouncements about the scope of Section 10501B preemption, in recognition of the fact that there is a very well-developed record from the district court in the Jackson case, now before the Third Circuit, and that court will be addressing many of the issues mentioned in your notice for this oral argument. I would respectfully submit and ask that the board focus on two key points about the New York Susquehanna v. Jackson case as you grapple with the issues raised in this proceeding, and in connection with other claimed railroad facilities to which the preemption issue arises. First, this is almost a truism, but it's an important one. There's no question that the Susquehanna is, and for a considerable period of time, has been a legitimate operating freight railroad. That simple but crucial fact, which Judge Hayden confirmed in her February 21 opinion, distinguishes the NYSNW from other entities that have come before you invoking preemption as the grounds upon which to contest state and local efforts to regulate aspects of their operations and facilities. In short, Susquehanna is not high-tech. You're familiar with the decision. You're familiar with the entity that sought to use your exemption procedures there. We are not high-tech, and the persistent efforts, candidly, of the New Jersey DEP and others to claim otherwise are unavailing, and Judge Hayden agreed with us on that point. We believe, and I think other railroads that have filed comments in this proceeding and the AAR have all indicated that the board can and should deal with the so-called rogue operator problem, as it's particularly evidenced in itself in this construction and demolition and municipal solid waste area, by heightening your scrutiny of entities which invoke the board's exemption procedures in an effort to be deemed rail carriers. That's the game that's afoot, and we all know that. The game is to be deemed a rail carrier, and then you cloak yourself in the claim of preemption to fend off regulation of a facility that may be nothing more than a facility at the end of a stub track or a side track. If your analysis of an exemption filing leads you to conclude that a particular entity would not actually provide rail transportation, that finding alone ends any legitimate attempt by such entity to claim the applicability of Section 10501 preemption for its facilities and operations. And you're done, and they're done. Second, the other aspect of the Jackson case I'd like to draw to your attention is that she reached her careful and reasoned conclusions both about the nature of the Susquehanna's operations at the transload facilities in North Bergen and the nature of the state's efforts to design and apply its regulations in a manner that inevitably and on purpose had a serious impact on transloading and serves local concerns. Those last words are not my words, those are Judge Hayden's words. She found the state's efforts were to design and apply regulations in a manner that, quote, inevitably and on purpose had a serious impact on transloading and serves local concerns. Those are the very kinds of concerns that Congress had in mind when it enacted the preemption provision in 10501B. Congress recognized, as I believe you do, that there needs to be a uniform national application of laws affecting rail carriers, true rail carriers and rail carrier facilities, and it is the classic NIMBY concern that animates many of the otherwise what we might agree on are appropriately understood efforts by local municipalities, states, regions to try to deal with operations in rail, around and in rail facilities, and not just involving C&D, and I'll come back to that point in a minute. We respectfully submit in these circumstances, that is the circumstances I just described about Judge Hayden's decision, that the board should not, and we ask you to be careful not to make any broad sweeping statements about the nature of construction and demolition, transloading operations and facilities generally. And certainly you ought to be very careful to consider the impact of any ruling in this matter on railroad transloading facilities and operations broadly defined. Moreover, if the board is inclined for whatever reason to go beyond the specific facts and circumstances of this case, and we would certainly urge you not to do that, we believe that the facts and circumstances of each individual case involving these claims of preemption are critical to the analysis. Judge Hayden agreed with that. We strongly suggest that you defer your determination in this matter until the judicial proceedings in the Jackson case have been concluded. You ask that as your first question, and it is our view that you should allow the court to act. That may not be hard because, as I said, the case will be fully briefed literally within 30 days. I don't know how long the court will take to decide the case, and if it will schedule an argument, when that argument would be, but my belief is that the Third Circuit has a pretty expeditious docket, at least compared to some other courts of appeals. Now, with your indulgence, in order to help you better understand the nature of the Susquehanna C&D facilities, and because we have confronted from the first day of the litigation in New Jersey, and again here today with Senator Lautenberg's exhibits, photos that are either photos of somebody else's facilities or might be photos of facilities that existed several years ago and no longer exist. I want to hand up at this time two counsel's exhibits that consist of several photographs taken in the last week or 10 days. There are, as you may know from the Susquehanna litigation, about 5 facilities in North Bergen that have been at issue there. These are photos of just 2 of them. I'd ask you again to bear in mind these are very recent photos. You'll see the dates on the cover, and maybe Mr. Hemmersbach can pass exhibits on to the rest of the room while we talk about this. These are very recent photos showing the way these facilities look today. I ask you, if you're shown more photos today, and any photos you see as you go through the record of this case, ask what the date of the photograph is and ask what the facility is you're being shown. If there is a solid waste facility that is not a railroad facility but happens to be, as the senator said, adjacent to a railroad, that doesn't transform it into a rail transloading facility. It doesn't make it a railroad facility. We have to understand who owns and operates that facility. Is it a railroad facility? And if so, what is the photograph showing you? Is it showing you conditions that are current? Is it showing you something that was there 2 years ago? The first of these exhibits is captioned NYS&W 83rd Street Facility, and these photos were taken on April 4th. And just very briefly, if we go in order, these are one of the construction and demolition transloading facilities owned and operated by the Susquehanna in North Bergen. The first photo shows essentially the entrance to the facility. There's a small office building. There are scales on either side of the building. A loaded truck pulls onto the scale, has its load weighed, is issued a ticket. He then backs into the building you see behind here. And there's nothing sophisticated about this, and I'm sure not going to try to suggest there is. I've been to these facilities. This is a very basic operation. We are talking about the debris that comes out of knockdowns of buildings from construction sites, teardowns. It's brick, it's wallboard, it's lumber, it's all the stuff you'd expect to come out of a demolition site. These trucks, many of which are coming from Manhattan, some from other parts of New Jersey, transport the C&D to one of these facilities, dump it on a cement floor, and as you can see in the background there's a front-end loader. There's probably a better shot of it here inside the building. This simply pushes this into a pile, and a grappler continuously picks the pile up and starts loading it into rail cars. And if you go to the third photo in this first set, you will see on the left side of the building, you'll see a rail car sticking out. That is the lead track coming back out of the back side of the building. So the cars are actually inside the building when the C&D is put inside. They're then covered with a netting, and the car is pushed out. The next car moved in for loading. Again, it's not sophisticated, but I would submit, Mr. Chairman, this is a very important operation for the people of New Jersey and New York. Why? There is no landfill capacity left in the state of New Jersey. This stuff cannot be disposed of in New Jersey. So if people say, leave it in the truck and take it 5 miles down the road, This stuff is going to Ohio. Some of it's going, we're told, to Quebec and other places, big landfills where there are permitted facilities to dispose of this stuff. It is going there by rail. The Susquehanna, as you know, it doesn't go to Ohio and it doesn't go to Quebec, so these are actually, interline movements. And it is a significant business for the Susquehanna. Quite candidly, in 2006, approximately 40% of the Susquehanna's traffic was from C&D. It's a growing business, and it serves an important public purpose. You'll note that these facilities don't have those large mounds that you saw in the photograph the senator put up there. That condition existed. I will concede it did. That kind of condition existed in 2005. By the time we got in front of Judge Hayden, those facilities are being closed down. The last open-air facility of the Susquehanna was completely shut down and cleaned up by December of 2005. She knew that. Her decision talks about that. She understood what the nature of these facilities are today. These are railroad facilities. The second exhibit, just very briefly, simply to show you the one other type of facility the Susquehanna has. It is not construction and demolition debris. This is the facility that handles contaminated soils, dirt, if you will, from Superfund sites. Usually, often the stuff I'm told has very low-level radiation or the like, and it has to be disposed of, obviously, in a much more careful and controlled manner. That's why you see a ramp up to the top of the building in that photograph. The truck's back up there. That door is open. The rail car is pushed underneath. It has a plastic liner that they refer to as a burrito wrap. The soil is dumped in there. Once it's dumped in, the burrito wrap is wrapped over the car. The employees who are working in there all have, I think, what we call moon suits, the protective gear, like you see astronauts in. So this is a special kind of an operation. The state doesn't like this operation. It says the only way, from their perspective, that it would be acceptable is if all that dirt were put in a concealed container and container-to-container movements were to occur. We don't believe that the law properly requires that, nor do the EPA regulations require that, but that is the state's position. So our primary message is the Susquehanna did not purchase an old siding and use your exemption procedures to become a rail carrier. It's a legitimate railroad with a long history of providing rail service. It has pursued the development of C&D traffic by developing these transloading facilities to respond to a clear market demand for transportation of these materials out of New Jersey, a demand that's most safely met by rail service. And it's worked with NJDEP, the Meadowlands Commission, and the localities in which it operates to develop and operate these facilities in an appropriate manner. Incorporating systems, these buildings have systems to deal with flow control of the waste. The debris does not come out the front door. If it gets to be too high, they stop, recede until the rail cars clear the waste out. They deal with traffic concerns. They deal with air and water runoff concerns. That facility I just showed you has runoff and settling ponds behind it. They have misting systems installed in these buildings to spray the debris to keep dust down. In short, what I'm trying to tell you is we have attempted to work with the localities to deal with their appropriate safety and environmental concerns, as your decisions make clear rail carriers should do. But New Jersey persisted in enacting a comprehensive regulatory regime, as I said, aimed solely at railroad transloading facilities. It didn't deal with some broader category of facilities. Railroad transloading facilities, frankly, in a blatant effort to discourage and ultimately shut down these operations. New Jersey wants to control this business itself. Judge Hayden recognized the anti-railroad animus that drove New Jersey's efforts. She quoted in her decision the then, and unfortunately because of Governor Corzine's accident, the again now acting Governor Cody, at a highly publicized press conference in 2005 when he pledged that, and this is out of her decision at page 10, quote, this is the governor, "We're going to harass the hell out of them. We want them to know that we're on their butt," end quote. And he was talking about the railroads. This is precisely the sort of local interference with railroad operations, often unpopular